Hi everybody, my name is Daniela Dane, even though my name tag says Andrew. So I'll just be doing the quick introduction. So today's presentation is going to be about the post-settlement update on Grants Pass. We'll review the background of the lawsuit, highlight the interim victories, plus that led to the settlement, and go over the details of the 5-year stipulated court order. We'll also discuss what the order requires, how to spot and report any violations, and share resources for people who have experienced property destruction. And after that, we'll have Q&A at the end. So in case you guys have any, questions you guys wanted clarifying. And I will pass it to Eric.
Thank you very much, Daniela. Just as a reminder, so LSPC is a support center. We do trainings, technical assistance, and advocacy support, especially for qualified legal services providers. So if you have any interest in future trainings or advocacy support or technical assistance, feel free to reach out, and we can work on that. So the first part of this series, so to speak, as Daniela mentioned, was done earlier this year, focusing on Grants Pass, the implications of the Grants Pass decision that the Supreme Court delivered last year. I'm going to briefly review that and then talk about a few cases in the West Coast that have applied that holding in the course of various procedural motions in litigation related to the criminalization of the unhoused population, and sort of tease out a few themes that I think are salient. And then Andrew is going to go deep into the San Francisco case that Danielle mentioned. So first, when we talk about Grants Pass, what do we mean? So I'm going to share a screen. Whoops. Okay, City of Grants Pass versus Johnson was decided in the summer of 2024. An opinion authored by Justice Gorsuch that found that the federal Constitution's Eighth Amendment ban on cruel and unusual punishment did not prevent a municipality from prohibiting camping in public places, including in its definition of a campsite was sleeping in a parked vehicle, as well as on the land, public property. Now, the City of Grants Pass had criminal fines attached to violations of its ordinance, and a sort of escalated scale of fines for multiple violations. And the plaintiffs in that case had argued that it was an Eighth Amendment violation under the then existing Martin versus Boise precedent that arising in the Ninth Circuit that the Supreme Court rejected. Interestingly, a lot of the analysis from the Supreme Court focused on the question of, effectively whether the status of being homeless was what was really at issue. One would think that a ban of this sort is targeted at persons who are unhoused, and that therefore it can be considered a status offense. There's a line of precedents in the Supreme Court from the Robinson case in the 1960s, which held that a status offense that criminalizes a status rather than action is an unconstitutional use of government authority. In the Robinson case, that had to do with being addicted to narcotics, but its application is broader than the field of drug use. And so the conception, and it remains, I think, a plausible one, even though it's been repudiated by the Supreme Court, was that a criminalization on public camping is really about criminalizing the unhoused. Court rejected that. It also rejected, or rather, it also, the way it did so is by categorizing camping as a voluntary action as opposed to an involuntary status. The court did not go in any detail as to what its conception of voluntary action is, but simply took it for granted that camping was an act rather than a sort of involuntary effect of the status of not having shelter. Court also emphasized that no selective enforcement claim had been before the court, so the avenue of finding that a ordinance like a municipal ordinance that criminalizes camping is being selectively enforced if one could meet the hurdles for making a claim of that sort. That remains a viable pathway after grants pass. It falls outside the scope of what the Supreme Court decided in that case. Interestingly, so Gorsuch's opinion doesn't even describe what the ordinance says. You have to look at the dissent from Justice Sotomayor to see what the court had said, and it prohibited camping on any sidewalk, street, alley, park, bench, or any other publicly owned property or under any bridge or viaduct. And that's from the Oregon Municipal Code in the city of, the Municipal Code of the city of Grants Pass, Oregon. As I mentioned, Robinson v. California from 1962 is the landmark case that clarified the scope of status offenses, or sort of serves as a landmark for it. Its extent, as we'll see later, is it's potentially still a topic of litigation, I think, after grants pass, as to what sorts of status offenses are prohibited under Robinson. Still, the court, majority of the court, definitely signaled a willingness to nip Robinson in the bud and limit its extent, and instead sort of attributes a ideological conception of voluntary conduct to find that an unhoused person camping in public space is engaged in an action that can be criminalized. So this theme, which the court really has no articulated philosophical theory about what constitutes voluntariness in this context. I suppose after grants pass, if one could make the case that a particular act of camping or a particular other sort of action of seeking shelter in a circumstance where a municipal ordinance prohibits it, if one can make the case that it falls within the scope of what's involuntary action rather than voluntary action, I think such a challenge would theoretically still be possible under grants pass. The grants pass holding is not so well defined first in terms of how it will play out in circuit courts, and as we go forward, it's not sort of like a done deal as to what the meaning of grants pass will be in other courts, and it would not be surprising at all if a few years down the line cases come before the Supreme Court again, having making it articulate further what this conception exactly entails. So I mentioned, the Supreme Court doesn't really have a theory of the voluntary here, that it's sort of a conclusory statement that camping in these sorts of circumstances is a voluntary action. It cites Blackstone for the conception of voluntariness, but does so without any particular analysis of it. And I think from a broader perspective, it highlights a certain fundamental, a sort of fundamental dynamic at the core of modern European-derived bourgeois law, as it was articulated in the 17th, 18th, and 19th centuries, and the ideological conceptions of which persist to this day, even though the social, cultural, and technological conditions in which those ideological foundations are applied are completely different. And in particular, the theme of the dynamic of freedom and necessity. You could say that essentially what supports the position that was rejected in Grants Pass versus Johnson is an idea of necessity. This is not, they did not raise a necessity defense in the classic criminal law sense, which incidentally, remains a theoretical possibility also after Grants Pass. But here, by necessity, I mean a broader conception of what are, the necessary elements of biological existence. What are the necessary elements of survival? But also, what are the needs that a human being has to exist with a modicum of dignity in challenging circumstances of social exclusion, and all categories of exclusion that can pertain in a disparate way to persons who are unhoused, whether it be former status of incarceration, whether it be mental illness, whether it be a disability, whether it be racial, gender, and as well as class effects. All these elements come into play. And in relation to sort of the experience of necessity that someone who is either unhoused or very insecurely housed faces, just in order to obtain the basic parameters of existence, to have shelter from inclement weather, to have warmth with which to regulate the temperature of one's body, or shade, and to have physical security from attacks by would-be assailants, and to have possessions, personal property protected from seizure by the state, as well as from damage from the elements, or being lost or stolen by other persons. Indeed, even the recognition of something as one's personal property becomes difficult for someone often facing conditions of being unhoused. So in the tradition, in the liberal tradition of the bourgeois theory of law, we have what is often called formal freedom as the basis. Here, there's a typo on my screen. I apologize. That should say right, the relation between right and morality. This is a contemporary or recent scholar, Neuhauser, talking about Fichte's theory of formal freedom, in which he says a person's freedom is not exhausted by its spontaneous espousal of ends. That is to say, a choice. To be fully free in the formal, even just in the formal sense, the person must be able to execute those ends in real action. A subject that is able to will its own ends but lacks the capacity to carry them out would not have achieved the full measure of freedom appropriate to the person. And here, the person is a kind of socially recognized status. Again, this is Neuhauser talking about Fichte's conception here. In order for formal freedom to exist, and this is even simply in the conception of bourgeois law and morality, right here meaning law, theory of law, the person possesses a conception of itself as an agent, that is, as a possible source of causality within the objective world. The philosopher Fichte's claim is that such a self-conception is achieved and solidified only by experiencing one's freedom, by encountering it in the world, encountering in the world the real effects of one's agency, by having before oneself objects of experience such as, they give the example, the house one has built, the cloth one has woven, or the fields one has cleared and plowed. A person's consciousness of itself as free derives from the real exercise of its formal freedom. And the idea is that if one's actions cannot be causally efficacious, according to this particular philosophical conception of freedom, even freedom in a formal sense cannot be truly said to exist. I think one could, along these lines, challenge Justice Gorsuch's conception of voluntary action, such that the voluntariness of camping in a public place when one does not have an alternative source of housing, that is to say that one's action in choosing an alternative to residing in public space is not causally efficacious, and therefore one's cannot be causally efficacious, and therefore one's freedom, even in a formal sense, is not present. And here, voluntas, the Latin origin of voluntary, basically means free will. One last philosophical reference before I just briefly mention a few recent cases in California and Alaska from the same era. This is early 19th century. Hegel's philosophy of spirit talks about how to be recognized is to exist. This is a kind of social philosophy of ontology or existence. My will counts as actual or existing, for to be recognized is to exist. Thereby my will counts, I possess, and the possession is transformed into property. So in this passage, from which I'm extracting somewhat violently, Hegel is trying to explain the difference between the possession of something and its legal status as property. So possession being the mere, having something under one's control, and property being a particular legal and hence socially recognized relation to possession. And he's generalizing from this distinction between property and possession to make a broader ontological claim that social recognition is the basis of the existence of something, or at least the existence of something as having social meaning is a function of the recognition of others, not simply oneself's conception and doing. And in that sense, Hegel's the difference between Hegel and Fichte is, among other things, an re-accentuation of the social, which is more underplayed, although still present in Fichte. And so this passage concludes, property is thus an immediate having mediated through being recognized. That is to say, it's not an immediate having at all. It's a mode of having something that is mediated through social recognition. And then he concludes this is its spiritual essence. That is to say, spiritual here could be translated in the less religious sounding mode as the cultural character of property. So a few cases applying, and why talk about property in relation to housing? So, of course, one of the functions of housing is that it is a place where one can store one's stuff and have, let's say, in addition to a reasonable expectation of privacy of one's person and personality, also a variable but not insignificant expectation of security in one's belongings. And one of the problems that municipal ordinances pose is not just that someone's presence in public space is being criminalized, but also their ability to possess things, including extra clothing that isn't immediately on one's body, or all the other belongings that someone may have, even though they are unhoused. Now, a recent case in the Northern District, up in the Eureka division, Piferini versus City of Eureka. There, the municipal code forbade involuntary, or forbids now even, involuntary camping at certain specified locations. This is crafted specifically to address, to fit into the line of cases that I mentioned that had, during the era of Boise, had applied the Robinson analysis before City Grants Pass was applied, but they did so in a way that, in fact, potentially enables it, the challenge to survive Grants Pass. Municipal ordinance forbids involuntary camping at certain specified locations. Involuntary camping on public property is lawful when and where it is not otherwise unlawful under the statute's provisions. That's the court's description of it, not particularly illuminating, but the following passage is, the municipal ordinance does not go so far as to specifically designate the areas where involuntary camping is lawful. Indeed, the ordinance specifically declines to do so, stating that there is no specific site or sites that should be designated for camping, because it is the experience of the city and other municipalities that sites where camping is continuous or camping populations are numerous become public health, environmental, and policing problems. So the idea is that if they specifically designate a particular area as a commons for camping, a place where neither public restriction nor private property will prevent people's common use of that area, then there will be a kind of moral hazard problem in the economic sense. Now, the plaintiffs objected to the lack of designation because it was unclear where the ordinance would protect them and where they would be prohibited. And so, the court also notes that the plaintiffs in Piferini challenged the application of the storage of personal property aspect. The ordinance had gave a definition for storage of property that as being to put aside or accumulate for use when needed, to put for safekeeping, or to place or leave in a location. Under the ordinance, quote, personal property placed in public areas shall be deemed to be stored if it has not been removed from public areas within 24 hours of written notice requiring removal. And it specifies that sort of moving stuff from one public place to another, especially in the same block and on a regular basis, will not be considered removal, and so that will still remain subject to the notice. And there were exceptions to some designated places that are definitely not allowable for involuntary camping. Now, the court basically upheld the general scheme of Eureka under Grants Pass, and distinguished it precisely on this idea of voluntary versus involuntary. And so they rejected the challenge that the plaintiffs in Viverini had given to the ordinance. However, it basically, and this was a, a pretrial dismissal motion, and the court did allow the property seizure notice. The claim that the property seizure notice was insufficient was allowed to go forward because the plaintiff had alleged insufficient notice and had adequately done so, even it hadn't been factually proven yet because we weren't yet at that stage of the litigation. But they were allowed to put forth that claim. And furthermore, they rejected, the court rejected monetary damages for that claim, but they did find that injunctive relief would be possible, and that there could be a substantial risk that sufficed for the possibility of equitable relief for the likely harm of having property seized with insufficient notice under Eureka's scheme. So that is, a promising avenue for attacking the seizure of personal property side of the Eureka statute, even though the broader Eighth Amendment claim was shot down under the Grants Pass line of cases. I want to leave adequate time for the other speakers, so I'm just going to go really quickly. There's a case up in Alaska, Pierce versus Cockerell. Here, the plaintiff had challenged the sex offender registry in general as a status offense that caused homelessness because of the difficulty of finding housing having been listed. And the court rejected that, and interestingly did so in a way that sort of defines the contours of the status offense under Robinson that survived Grants Pass. Basically, the court in Pierce found that a regulatory status such as registration requirement still survives the Robinson line of cases, and that it is not impermissible under Supreme Court cases, and that therefore, even though there wasn't a specific identifiable conduct as there was in Grants Pass of camping, the regulatory status was not an improperly criminalized status. Another case of note, which perhaps we can return to a little bit later, is the case out of Monterey, and that has to do also, again, at a pretrial stage with the application of Grants Pass principles. I will turn it over to Andrew, and if there's time at the end, maybe we'll talk a little bit about the Monterey case. Thanks.
Thank you, Eric. Very comprehensive as always. Let me see if I can get this to work. Great to meet you all. It looks like there's 20 of you over there, and really appreciate you taking the time. I'm going to ask for some, before I do this, I'm going to ask for some audience participation. So and I think I should be able to see this. I'm wondering who on here was either at the previous webinar or has familiarity with the Coalition on Homelessness for San Francisco case. So raise your hand if that is you. because I had, there was a previous webinar that went more in depth into some of these pieces. And I don't want to duplicate that if everyone's done it before, but I feel like there are a few pieces. Okay, I'm seeing a handful, but not everyone. I also don't know if everyone is in a position to raise their hand. So I will go in a little bit of depth into some of the background as well. But I haven't even introduced myself. My name's Andrew Ntim. I'm the Thurgood Marshall Fellow at Lawyers Committee for Civil Rights on their racial justice team, working on various litigation pieces related to criminal justice, poverty, incarceration, all of those things. And I've been a part of the coalition case for the past 2 years now, from when we first got our preliminary injunction to when it settled just a couple of months ago. And want to take this time basically to discuss what has happened since the last webinar, and speak a little bit more to some of the implications on work around advocacy for the unhoused population generally. So giving some background on the lawsuit, the interim victories, spending some time with the settlement. I know I shared the actual language of the settlement with folks beforehand, and because we have a largely legal crowd, want to dive into a bit of that language, and then just some moments for lessons learned, next steps, and ways to get involved. Some disclaimers. So again, I can't speak to the specific negotiations that were made in the settlement. I'll speak very generally to some of the things that are in the settlement. I'm also not going to, another version of this presentation had, how to spot, for kind of frontline providers, how to spot violations and who to get in touch with. I'm going to skip over that. And because our work has been kind of separated from the criminal element of homelessness policy for a while, kind of since grants pass, I'm going to be speaking a good deal less on that, and I have less to speak about. But I think that that's a place where organizations like the Housing Not Handcuffs Coalition and the Equal Rights for Every Neighbors Coalition um, can really step in. So I'm going to be giving some information on those later on. Um, so I'll go pretty quick through this. So our lawsuit, Coalition on Homelessness versus the City of San Francisco, was filed by the Coalition on Homelessness and a group of unhoused people. It was a multi-plaintiff piece of litigation, not a class action. Um, and it was filed because the city was routinely destroying its folks' personal property during encampment sweeps without notice or documentation, in violation of its own bag and tag policy and the Constitution. We were never alleging that the bag and tag policy was unconstitutional itself, more just the way that it was being used. And the original lawsuit again also argued that the city was illegally criminalizing homelessness, but those claims were dismissed after the Supreme Court ruling in Johnson v. Grants Pass, and that is the Eighth Amendment piece around criminalizing homelessness. So the laws criminalizing homelessness, many of them are still on the books in San Francisco. Some are being enforced in different ways. Since the new administration, there's a new mayor, Mayor Lurie. But they're largely still on the books. But the Fourth Amendment pieces, which were kind of the primary basis of the bag and tag violations, are still present. So the lawsuit was not seeking monetary compensation. It was really focused on this court order injunction to enforce the constitutional rights. And in December 2022, we received that temporary court order preliminary injunction requiring the city to follow its bag and tag policy. We also initially got a preliminary injunction on the criminalization of homelessness piece, but again, that piece of the PI was rolled back after grants passed. And had basically we got a court order again enforcing this preliminary injunction that went up on appeal initially, and we won that appeal. And the court ordered an overhaul of the city's training practices as a result. But we continued to see violations, so continued to see the case through. And then in July 2025, just a couple of weeks before the case was scheduled to go to trial, parties reached a settlement of the lawsuit that resulted in a 5-year stipulated injunction. So there's continuing jurisdiction over the case for 5 years until July 2030. Be great if it was 3030. Who knows what San Francisco would be like in that. So this was a really critical, perhaps one of the most critical parts of the settlement, that we had this continuing oversight in the stipulated injunction, often very difficult to get different jurisdictions to agree to these sorts of things. They really don't want the stipulated injunctions in this capacity. But we were really I won't say lucky, but we are happy that was resolved in that way. Now, this has some details on the injunction. Again, there's more details in the materials that I provided, but a few other small pieces of it. There were two remaining individual plaintiffs. There were several plaintiffs who some who settled out and some who had been dismissed, kind of based on standing and on prior settlements. This is something that I think has come up many times and is quite difficult, and that I think courts will always argue about when you have multi-plaintiff and not class action suits, that if people are housed, even very tenuously housed, that they no longer have standing and shouldn't be able to continue to be part of the lawsuit. So the two remaining individual plaintiffs who were housed at the time and were able to escape a lot of the standing related arguments that the city were making received compensation. And the city also paid attorneys' fees and costs to compensate attorneys for their time. And a portion of the fees will be used to pay for staff at the ACLU to monitor compliance with the settlement for the 5-year court term. So this was another important piece, kind of this ongoing monitoring and enforcement having funding associated with it, a pretty substantial portion of funding, allows us to continue doing this work, and especially given the nature of this, and how many sweeps are happening, how many folks are unhoused, it was really critical to make sure that we could continue doing this work. And these regular observations of sweeps will continue to happen, and there will be court intervention if there are any documented violations. And I'm just thinking of time here. Some other pieces of the court order include strict following of the bag and tag policy, advance notice to coalition and unhoused people, and I'm just going ahead to make sure. Yeah. Enhanced documentation and encampment sweeps, including writing down of everything that is there, and acknowledging when they have given the pieces of notice, more detail on the notice. In previous times, there sometimes was notice, but it would be 6 blocks away from where the encampments actually were, and they would have very large kind of sweeps of areas where the sweeps were happening, and so that's now changed. Regular reporting to the coalition, continuing to let us know in advance when these sweeps are going to happen, and providing information of the bag and tag that's actually occurring. There's DPW yard inspections. I believe it's quarterly, where in the past it was very, very difficult for us to get into the yard, which is where DPW is the Department of Public Works. The yard is the location where items that are bagged and tagged are taken to be stored, which in theory should be for I believe it's 90 days, but it was very difficult for, number one, for folks to get their possessions, but also for us to monitor and see what was actually happening in this yard. And so then there is a new set of minimum standards that must be followed if the city changes its bag and tag policy around both notice and the actual bag and tag process. So I'm just looking into here. Okay. So a few other small things, and I want to leave time for questions, so I'll be pretty quick here. I mentioned some of these things, requiring 72 hours advance notice to encampment residents, 30 minutes for all encampment clearings. This includes when folks are calling 311 or when the police are called or anything else, at least 30 minutes time for owners to remove their property. And just much stricter requirements for the storing of attended or unattended personal property that is not removed by the owner. And yeah, so this is the case for unattended and attended property. This was also a very important piece of the settlement, kind of the distinctions between those and the distinctions between unattended and abandoned property. So there's specifics around that in the settlement as well. And a lot of back and forth. Well, I won't say that. So and another piece of this that we had seen is the way that disability interacts with sweeps. What we heard, many people were given almost no time, like less than 10 minutes, to collect and secure their property, who were in wheelchairs or had other various issues going on. And now it was always supposed to be the case, but we're under the stipulated injunction that the city must provide additional time to folks who to move their possessions. Yeah, so we got all that. The city is providing notice of its sweeps in advance, and doing more photographing of the information frequently. They would be taking something and not leaving these post removal notices or anything else like that. And so there are various changes with that. And again, so the current bag and tag policy remains, but there are new standards if there are future policies around 1 hour of advance oral and written notice for unplanned sweeps with attended property, and 4 hours for unattended property, and 48 hours for planned sweeps. And what we heard from unhoused folks is that even just this 1 hour is very important because of the way that shifts and shift change works. Within DPW, often folks will, after they make the notice, they'll say it's an hour, but they won't actually be able to come back until after a shift change, 6 or so hours later. So what we see is that, it really is important to ask about how things work on the ground, and how your public works department actually works and function, in order to provide, craft a settlement that's actually effective. And again, things around disabilities will continue to be there in future policy. Enforcement, it is required to have 10 instances of wrongful property destruction in a 90-day period for us to bring the matter before a judge to seek relief, to address noncompliance, which could be an enforcement order, could be anything that the judge deems proper. And the city is required to investigate and provide documentation related to the incident for the city. And this is the important thing here is that they need to be brought to the city within 10 days notice. So we're trying to create a pretty robust system for monitoring and ensuring that folks can bring these issues to us and can get support in that process, and building community relationships. I'm the one leading a lot of the community education, and will be, regularly dropping into different community centers to ensure that information is clear, and that if there are violations, folks are bringing them to us. And then again, the other version of this has a lot more on our process for documenting and following up on these pieces. We have a clinic regularly where folks are coming in and potentially can look into this. We're also supporting people in filing administrative claims and small claims cases against the city to receive monetary compensation, because folks are not getting monetary compensation when they bring information specifically on this court order, et cetera, et cetera. But I'll skip over those things all for now. And I want to leave at least a minimum of 5 minutes for everything else. So I'll speak very, very briefly to lessons learned and reflections, and then what else do I have on here? So the monitoring, enforcement, and transparency were some of the most critical components of this settlement. As folks know, if there's not, a stipulated court order with continuing jurisdiction, it can be really, really difficult to ensure that these violations don't occur again. And so that's something that's very important that we were able to get. The risk of appeal in the current landscape, even though we think we got a pretty good draw on our judge, it was very difficult to know what would happen on appeal, and potentially even going up to the Supreme Court and understanding how the shadow docket has been working on civil rights cases recently. So that was something that definitely contributes, I think, to everyone's risk about bringing these suits to trial. Changing conditions on the ground and how they inform advocacy efforts. So, San Francisco, from a statistical perspective, has had less, reports of tents and structures on the street. But it's had more folks that have been have been vehicularly housed or sleeping totally rough with no tents. Or anything, and that changes the calculus and the process for how we might want to craft legal relief. So having continued flexibility with the what's going on the ground was really important in making sure that we crafted that settlement in an effective way. And there were a lot of other things that happened in the process. There's a new RV ban in San Francisco that very unfortunately took place. And will be going into effect in the coming months, that creates parking bans, and making sure that things like our settlement will apply even under new legal regimes like that. And then the integrated advocacy and media needs. We received unprecedented pushback, I would say, both from local politicians, from business leaders, from just media agencies, all the rest about every piece of this litigation, from when we first started it to the PI to the settlement, every piece of it. And we have an incredible comms team, both here at LCCR and at ACLU, that was able to help us weather the storm, continue to put our messaging out there, and continue to advocate for long-term solutions to homelessness in the form of more housing and less criminalization. And I think, I can't speak to the sentiment generally, but I know many people, the reporting on this work, which really would not have been possible without either our clients or our media team, really opened folks' eyes to how sweeps are actually impacting folks, and hopefully will support in helping us do further advocacy in the future. I'm gonna skip over this. This is a slide that I had in the previous version of this presentation, speaking to alternative legal strategies post grants pass, how we might think about opportunities for attacking criminalization, especially. So this will be in the final slide, and folks can look at it later. And this is also just for reference from the previous slide, some of the criminal and civil laws that are affecting homelessness beyond property. And yeah, last steps for advocates. So these are some things that I had in the previous version as well, but the Housing Not Handcuffs and Equal Rights for Every Neighbor Coalition continue to advocate both for legislative and legal solutions to the criminalization of homelessness and the theft of unhoused people's properties. There's actually annual strategy convening happening next week. Oh my gosh, that is next week. To about kind of potential strategies in the new year. What we're seeing is that there have been less, attempts at kind of litigation responses to a lot of these things. There was some potential litigation in Oakland that folks had floated, and that ended up, folks were afraid of the potential risk there. There was potential litigation in Fremont over a new ordinance that potentially would have criminalized the aiding and abetting of homelessness, which is to say the support of unhoused people. And that is and that lawsuit was used to inform legislative advocacy, but was eventually dropped. And so there's a lot of kind of new strategies, new extra legal strategies that folks in these two coalitions are focusing on, that I think are very specific to your local jurisdiction and the legal landscape. So I would highly recommend reaching out to those folks if you have specific questions. And the continued way to do this work is to be in community with the folks that you're serving, supporting frontline sweeps defense and mutual aid collectives in your community. That is, without those relationships and those continued forms of reciprocal forms of care, we never would have had the strong relationships with both the plaintiffs and the organizational plaintiff and the witnesses that were a part of this case. And it's just so extremely important for like when you're working for any population, but especially this population. So, sorry for taking up so much time. I will close out there. I have my name and email if you want to reach out further. But I definitely want to give some time for questions and for Yoslin to close out, and I can go a few minutes over as well. But yeah, that's it.
So we got a question in the Q&A from Phyllis, who wants Andrew to briefly explain what bag and tag
Oh,
means.
I'm sorry, I'm
Is
sorry.
that a specific form and technique of seizure, or would any situation where personal property is being seized be a bag and tag?
I'm sorry about that. And that I didn't see that earlier. Bag and tag refers to the particular policy in San Francisco where they are required to um, basically when property is being taken, they provide basically property receipt that states, the property that was taken, who took it, where they can pick it up, how long they have to pick it up, all of those sorts of things. And then they put it physically in a bag and bring it to this Department of Public Works yard. So this is not strictly required for every jurisdiction under the law, but and some sort of process by which people can obtain their property, whether it's through this particular form of property receipts or something else is the process. But bag and tag is the colloquial form or term for the policy. So you can also look up their specific policy.
And Rachel's interested in knowing what, since the settlement, have you seen on the ground? If there's been any development since the settlement was approved.
Yeah, so we have a new mayor, Daniel Lurie, and I feel like every mayor comes in and wants to dramatically change the process for responding to the unhoused crisis. So there have been some positive things. There are more shelter beds. Proportionally, more people are in shelter than sleeping rough. Though obviously we know many of those shelters are not necessarily accessible for everyone, things like that. Um, in terms of and because there, are fewer people in tents on the street specifically, the exact numbers that we have seen of citations related to specifically bag and tag are also going down. However, there is also the I forget the specific law, but like the rescission of Proposition 47, such that there can be greater penalties for like lower level property crimes, is something that is impacting as well, and that we have heard from public defenders that more unhoused people have been charged with these lower level offenses, and then that can be used as a threat to force people to move even if they don't necessarily if there's not like a specific legal basis for it. So there's a lot that's moving and changing because we're relatively new in this administration and don't have a lot of data on it and are only starting our monitoring process in earnest now for the settlement because we're just starting to get the data and the transparency from the city. But that will I think that all of these various conditions, as well as the larger, political landscape, and the sanctioning of these very right-wing policies towards unhoused people and all oppressed people by the Trump administration will continue to be important. And I will also say look back at the last presentation, which has some of the policy changes that had occurred kind of from Grants Pass to February, March of 2025. And I see Allison's question as well, which I will answer very quickly. From your perspective, what were the factors that drove? Sorry, sorry, I didn't read it. And I saw you deleted it. Oh no, it's answered. It's an answer now. Okay, from your perspective, what were the factors that drove the city to agree to continuing oversight by the court? I imagine they fought tooth and nail to avoid it. They did. I cannot speak to the particular negotiations that were a part of that. But what can I say? Um, we had a lot of evidence. We had a lot of evidence. This has been a very expensive and a very long process. I will I can, infer that there were some media and PR components of it, and that the new administration had a different approach. Daniel Lurie has a very, direct relationship with some of the advocates within the coalition on homelessness. And so there were many pieces, but I can say that, there's to all settlements, there is a give and take. Um, and there are some things that we were happier about and some things we were less happy about in the final agreement.
Daniela, do you have any closing observations?
No, but I was just gonna ask Andrew, could you go in a little bit more about what was happening in Fremont? You're on mute. Oh, sorry, you're on mute.
Thank
Thank
you.
you.
Thank you. I am not a Fremont resident, so I apologize if any of this is incorrect. But to my knowledge, in Fremont, I think this was at some point early this year, there was a bill that kind of more aggressively criminalized homelessness in Fremont than in many other places. And in particular, the language that was in there is that it initially included an aiding and abetting clause that had the possibility of making it a misdemeanor to help unhoused people, provide them with tents, provide them with resources, other sorts of things. And so that was initially approved in February. And there was a huge kind of public outcry around many pieces of it, but especially around the aiding and abetting language. And there were many organizations that were thinking about suing, and there was questions around, can you do a pre-deprivation lawsuit or only after someone is, actually charged or arrested with it. And then there was another city council meeting, and the city voted to remove the clause of aiding and abetting in March of 2025. But there's still very problematic language in it around both kind of how it could impact other organizations, but obviously how it could impact unhoused people specifically. So this is so the lawsuit was withdrawn just last month in September, but there continues to be legislative advocacy around changes to that.
Thank you. And there's 2 more questions too.
Yes. Okay. I'm going to read the whole thing. In Salinas, the location where they take the property is miles from where the homeless people tend to live. Do you have any thoughts on how to address that? It's effectively thrown away because people can't go miles to retrieve it and don't necessarily want what's remaining. Also, they tend to throw away a lot of stuff as garbage and are very selective as to what they put into the 9-gallon containers and keep. Yes, so this kind of, speaks to the really critical difference of unattended versus abandoned property, and how long folks have to retrieve the property if it is unattended, and also how they designate, quote unquote garbage with property. And there was a lot of back and forth, both in the PI and in the settlement, as to what ultimately the definition of those things would be. And if it's commingled with things that are considered health risks, it's can be immediately destroyed. But if not, it's all those sorts of things. I think that in a perfect world, there would be much stronger positive relationships between these various public works departments and the unhoused people themselves, where they could, very clearly designate like this area is trash, and I will always leave my trash on this corner, and these are my possessions, and I do not want these possessions to be taken. And I tend to be out during the day, so you can know that this is happening. And there are some reports of certain DPW officers, workers that have personal relationships with unhoused people and are able to work through those particular things. But I think that what we often see is, yes, they're folks that when there is this thought that there is this commingling of trash and property, that everything gets destroyed, especially when there are quote unquote public health implications, and that things, unattended property is taken and then you know, the bag and tag logs that folks are supposed to have, the property receipts, they don't actually ever find them, so they don't know where they can return the things, return to actually get the things. So it's very fact specific, but in theory, I think that this settlement shows that it is possible to create a regime where, at the very least, there's extended notice before unattended property is taken, and there's opportunity for people to get that unattended property back after it's taken. And again, folks have 90 days in San Francisco to get that back, except for certain bulky items. So I consider that to be positive. Rachel Horder, can you share any takeaways for continuing advocacy on behalf of disfavored, marginalized communities and issues? I'm not on the media team, and so I can only speak on certain pieces of this. But I really think that as much as possible, having like individual human stories is like such a critical component of this. And we just had some individual plaintiffs who really I was so extremely inspired by, both in their stories and in their willingness to share those stories with the media, with the court, in these extremely invasive 8-hour depositions where they're asked about every piece of their personal lives. We just had some people that really were willing to put themselves out there. And I think you can't compromise when it comes to certain pieces of this. I think that there, you know, is a general desire to you know, in modern discourse, to like push towards the middle and try to bring in more conservative voices. And I think we took a very hard stand on the humanity and rights of unhoused people, and discounting the rhetoric of unhoused people as you know, dirty, as drug addicts, as any of these things, because it's not true. And we had a really strong organizational partner who was able to help, who has been doing a lot more media work, that was able to help kind of us craft that narrative. And do I think that it was totally successful in kind of changing, you know, the most right-wing people's opinions? No. And I don't think we were trying to do that. We were really just trying to cut through the misinformation and ensure, you know, that people's humanity was respected. But I really think that it came to those folks themselves being able to tell their stories, and us just supporting them and doing that.
So I think we're about out of time. I want to thank Andrew and Tim from LCCR-SF. Thanks to the LAAC for hosting this. Remember, if you want MCLE credits, to fill out that form and to do an evaluation. And thanks to Daniela Dane for her participation. And you know, there's a lot to talk about, so feel free to email any of the participants after this, and hopefully we can continue this conversation later. I'll turn it over to LAAC if they have any outro material.